That means Article 5 of Chapter 90, so drug crimes. And the defendant has to obtain substantial income or resources as a result of their efforts. So that brings me to our first issue, whether the series component of the offense is just one element, or whether each individual violation that makes up the series constitutes its own essential element that has to be proven beyond a reasonable doubt, submitted to the jury, and then found unanimously. And the U.S. Supreme Court in Richardson v. United States, when analyzing the federal analog, took up just this question and concluded that yes, each individual violation constitutes its own essential element. There were good reasons for this. They focused on text and tradition, particularly the use of the term violation. But they also looked at some pragmatic concerns, that it would basically aid in jury deliberations by forcing them to sort of dig into the evidence more deeply and not really letting them paper over any disagreements about what the defendant may or may not have done. Now, it appears that the state does not actually disagree with us on these points. First, that a series must include at least 3 individual drug violations. And second, that each violation constitutes its own essential element.
Where does whether the state agrees or not, we're tasked with statutory interpretation. And with series, obviously, I think that's something that, even if it's not in dispute here, isn't exactly clear what that is under the statute. So what is it that we're basing that a series has to be 3? Why isn't a series 4 or 2?
Series, for why it wouldn't be 2, I would think plain language. You would usually use something like pair if you're just talking about 2. A series could be 4. But every federal circuit, I believe, has addressed this issue. They have all settled on 3. That's a number that the United States Supreme Court assumed in Richardson. So if we wanted to set a number higher than 3, you'd certainly be able to do that. But it does seem like 3 is probably the lowest number that you could have while still making the word series appropriate. But that brings us to the part where I think the state and I actually disagree, and that's about whether or not each of the individual violations has to be distinctly alleged in the indictment. And the answer to that is yes. Under long-standing North Carolina law, to be facially valid, an indictment must allege each and every essential element of the offense. Otherwise, a trial court lacks jurisdiction over the charge. I understand that the landscape on that may be shifting a little bit. That's why I filed a memorandum of additional authority citing Newborn and JU from our Supreme Court. But if you read those carefully, I think what they're doing is there's a subtle shift from having to allege each essential element, like sort of laid out distinctly, versus having to allege facts from which all of the essential elements could be inferred. But if that's right, and if that standard is getting a little bit looser, I still think the indictment in this case still fails under even that standard. The language from the indictment is that the violation was part of a continuing series of violations of Article 5 of Chapter 90 of the General Statutes. I don't think there's any way to read that and pull out 2 distinct drug violations that you would need to constitute the rest of the series. The first part is the primary that is alleged before that in the indictment. So the indictment didn't allege each predicate drug crime, and it's not possible to infer from that language any individual predicate drug crimes. So the appropriate remedy under a long line of cases would be to vacate the judgment. And I did make sure to cite in the memorandum one additional case that was after Newborn and JU. That was State v. Taylor from this court, where they vacated a conviction based on a defective indictment. So the remedy appears to remain the same. So if there are no questions on that, that brings me to my second issue. Whether our CCE statute should be construed so that a defendant who isn't any type of supervisor or leader or organizer and doesn't earn any substantial income from the enterprise could still be convicted of the offense based on a theory of aiding and abetting. The answer to that is no. This should be a carve-out from the usual rule allowing aiding and abetting liability. The central task of statutory interpretation is always to give effect to the intent of the legislature as best as possible. And I understand you start with the plain text, but you also look at what the act is trying to accomplish, the context in which it was passed, what other legislation might have been passed around the same time. And so here, looking at this as a whole, I think the manifest legislative purpose was to create an offense focused on drug kingpins as opposed to lower-level participants in the enterprise. The offense is defined in terms of occupying a supervisory role. It includes a requirement that the defendant obtain substantial income or resources. There are strong forfeiture provisions, and it authorized much harsher punishments than were available for most other drug crimes at the time. This was true when it was passed in 1971 as part of the Controlled Substances Act. At that point, you could actually get a life sentence. There was a mandatory minimum of 10 years for this, but you could get up to a life sentence. Then the statute has been amended only one time, and that was with passage of the Fair Sentencing Act. And that set a 20-year presumptive sentence for engaging in this offense with a maximum of 50 years. So in short, the General Assembly, following Congress, created an offense that was uniquely focused on kingpins. Allowing guilt based on a theory of aiding and abetting would contradict that manifest legislative purpose by allowing the state to prosecute and punish even low-level participants as if they were kingpins too.
Well, couldn't the statute also be designed to get, under aid and abet theory at least, anybody that's really helping support this, even if they're not the low-level drug dealers? They could also be the office secretary that's, passing around, jobs, just helping somebody schedule their day of, hey, we've got, you've got this large meeting, you've got that large meeting. Why couldn't it apply there as well?
So you're talking about the distinction between sort of what the Second Circuit endorsed in Amen and what Judge Posner, writing for the Seventh Circuit, endorsed in Pino Perez, where Posner would have allowed aiding and abetting liability for those who were sort of outside of the organization. One of the better examples of that is probably Ambrose, where
not necessarily outside. I mean, they could be part of the organization, but say you've got, somebody that basically just serves an administrative secretarial role, never touches drugs, never moves drugs, doesn't really care about drugs, it just knows what the kingpin's doing and schedules all their stuff for them, does administrative tasks, never touches a drug, but knows what's going on.
Well, that would still run into the problem of coming up against legislative intent and what they were trying to do, because the whole idea was to set up the specific offense for drug kingpins, for the leadership of these enterprises, in a way that would treat them differently than other members, other participants in that enterprise. So whether or not they're touching the drugs, if they're lower down in the organization, it really shouldn't apply to them. This is really intended just for kingpins.
What separates, based on the language of the statute, this and pulls out the aid and abet?
What pulls it out?
Yeah.
The best textual example, and the state points this out actually, is the supervisory role, that you cannot be directly guilty of this offense unless you're a supervisor of at least 5 other people. And allowing guilt.
I guess I'm not getting my question through clearly, so let me just think I'm rephrasing it. I unfortunately skipped my cup of coffee this morning, so bear with me for just a second. Let's look at aid and abet of murder.
Okay.
Right? The person who aids and abets did not commit the murder.
True.
They're going to be punished. Obviously, you don't have the step up, you've got the step down.
Mm-hmm.
But they're going to be punished pretty severely.
Yes.
For aiding and abetting a first-degree murder. So aid and abet is a very important thing that the legislature legislates against, common law is against. So what in this statute shows that we're wanting to cut against that in this limited situation? If we're cutting against something that exists in common law, has been recognized by statutes in terms of our punishment levels, what here says no more 8 or better for this principal crime? The principal crime being, yes, there's this kingpin that's doing all these bad things, he's supervising and the like, but we're still going to punish him as aiding and abetting. What's to show me that that general principle is not going to apply?
So why should this be treated differently? Because this offense appears to be unique in that it is about supervising a criminal organization. The murder example that you gave, that's a completely different type of crime where aiding and abetting makes more sense. It's not set up the same way to single out the leadership. Does that make sense?
I guess maybe I just disagree with, leadership and principle seems like the same. In a murder case, you've got a principal that commits the crime.
Well, if I could say, I think it seems to me what you might be saying is that this particular offense, the principal crime, we'll call it itself, the continuing criminal enterprise, the elements require sort of an organization with at least 3 levels. We've got a supervisor, we've got intermediate people they're working with, we've got lower level people. Whereas a murder